in the subject and also take an active part in the deliberations. Now, this session, as you know, is dedicated to intellectual security, intellectual property rights, and technology transfer. Since yesterday, as a part of this two-day connectivity conference, we have organized 4 plenary sessions and 3 parallel tracks so far, where we have had excellent deliberations. And now, apart from this parallel track, we are having 2 more parallel tracks simultaneously happening in 2 other halls. The objective of this session is to have an idea of the unparalleled potential of emerging information and communication technologies and how it is contributing to economic development of the countries of South Asia. There will also be deliberations on how the lack of a single regional policy narrative in technology transfer and the enforcement of IPR, intellectual property rights, laws have contributed to low rates of technology transfer and piecemeal investment in core research and development. Before I invite the speakers onto the dais, I have an announcement to make. We are using, as some of you would already know, Slido or Slido, as someone called it, which is an audience interaction platform. So please log on to sli.do and join hashtag RCC 2018 event to post your questions to the panelists. You can also use the Slido app from your mobile phones. Please do post as many questions as you want. With this, may I now request the panelists to come onto the stage. Mr. Sujeev Shakya, the chair, Nepal Economic Forum. We have Mr. Santanu Mukherjee, founder and head, ex-Lege Chambers, New Delhi. Mr. Mukherjee. Ms. Shilpi Jha, Senior Legal Counsel for Intellectual Property, South Asia, Embassy of the United States of America. And Mr. Parag, Vice President, Government Affairs, India and South Asia, Qualcomm Inc. So I request Mr. Shakya to moderate the session and carry on with the proceedings. Thank you very much.
Thank you, Ratinder. And yeah, so we can get started straight away. And I'm just here as a glorified timekeeper. So I'm just going to ensure that we are all going to get out of the room at 3 o'clock. I've got a clock right in front of me. And we've just had a discussion on how we are going to curate this session. Maybe just like since we are not too many of us, maybe we can just huddle around in these front, sort of tables, and then so that make it a bit more conversational and a bit more interactive. So we will not just wait for everything to finish and come for questions. So if you have any questions in between, please do raise your hand. We can just start discussions. And also, as Ratinder mentioned, there's Slido. And do tweet at hashtag RCC 2018. So I've been doing a lot of tweeting around. So maybe we'll just start with, everybody has the bio on their folder, so just not much of introduction, but straight go into Shantanu's opening remarks. So everybody may just within 10 minutes, set the stage on how you connect with the topic. How do we, look at the single regional policy narrative, from the experiences you've been working on. So we'll have a round of opening remarks. Maybe then we can start opening up for questions and then take the conversations further. Shantanu.
Thank you very much, Sujeev. Pardon my voice, I nearly lost it. So, first of all, I see it's more a nice, warm, sit discussion rather than a very serious discussion on IPR, technology transfer. So first of all, when we talk about connectivity, because the whole conference since yesterday had been on connectivity. Physical connectivity, whether land or by water, and all these discussions have been going on. I think what I would focus here and try to bring in a narrative, try to bring in the perspective of digital connectivity. If you think of digital connectivity, and then talk about tech transfer, because otherwise it goes so wide that we lose track, and in each, it can be a parallel. So we look into digital connectivity, and if you look into digital connectivity, you'd see ICT is based on innovation, and it brings in innovation. And this innovation is on a very broad spectrum, whether it is, I mean, it can be used in cases of health, education, essential facilities, as well as other areas. And this is basically if you think of connectivity. Now, when you talk of innovation, automatically, we think of innovation in the perspective of intellectual property rights. How do you protect the innovation? You protect the innovation through intellectual property rights. And then, if you think of innovation, whether it is the innovation, you create the innovation and you need to protect it, or you acquire the technology is acquired and the innovation is acquired, or you just use the technology. You just, neither you innovate nor you acquire the technology, innovative technology, but you just use it. In whatever you do, intellectual property rights come in. There's a direct relation. Now, when we see connectivity, direct relation with innovation, very often we think that all technology transfer is based on intellectual property rights, or there's correlation with intellectual property rights. That is actually not correct. It is erroneous, because there are a lot of research have been done, and even Cuts, they have done research with Professor Keith Maskers. And Keith Maskers, in last year, one paper he showed that the technology transfer can be market-mediated transfer, maybe non-market mediated transfer. Now we bring that, when I say market-mediated and non-market mediated, what is the difference? Market-mediated comes in with the FDIs, comes in with the licensing, comes in with joint ventures. This is market-mediated. And when you see non-market mediated, the patent data which is already there, the data from the test data which are available, publications, science and technology publications which are available, that data is already there. Then, of course, there is reverse engineering. So far it is legal. This is non-market mediated. Now, in that scenario, when you come to policy, typically the innovation in the industrialist countries is driven nearly approximately 2/3 by the private sector. Whereas in the developing countries, it is just reverse. With the public sector investments, it's more. In that scenario, if you think it is market-mediated tech transfer more from the technology-rich countries, the flow of technology coming from those countries, what happens is there is a mismatch in the focus. When you are there to draft a policy, the takers of the policy might try to reduce the cost of the technology and opt more for the non-market mediated. This is what we see have happened since quite some time. Now, in this scenario, we sit down, all countries, whether developing or not, we need FDI. We need licensing. If that's so, how do we come to a sort of one policy which matches both? This is a mismatch. Let us discuss in the conference more, because I don't want to spell out all the bins. How do we bring out a sort of single match there? Because without the IPR protection, the market-mediated FDIs and the market-mediated licensing is not going to happen. And the developing countries, they would, they would prefer as much as possible the generically tech transfer happens. So in this area, we'll see as the discussion proceeds how we take it forward.
Thanks, Shantanu. Quite a bit of food for thought for us to ponder upon. So start thinking of some of the questions you may want to pose to Shantanu, and we maybe move it to Shilpi and your opening remarks.
Thanks, Vipul. So I will take a little bit of time on explaining my job responsibility so that you understand why I'm here today. So I'm Shilpi Jha, as he just told you. I work with United States Patent Trademark Office, and we cover SAARC nation, all 8 SAARC nation here. Our job responsibility is basically to do a lot of policy advocacy on intellectual property right, and while we do policy advocacy, we do a lot of technical training program or support to that program. And we cover, as I said, all SAARC nation. So our office role becomes very important for a conference like this, which is like regional connectivity. And I'm really happy and pleased that the organization have considered to have IPR as one of the track. I'm sure next year we'll have a better gathering here because people will appreciate why IP is important in today's scenario. Shantanu has already spelled that having IP or looking into intellectual property right is very important in today's scenario with the globalization and all. But more so, it's important with regional connectivity because unlike rest of the law, like we talk about family law, property law, those are all country-specific law. But when it comes to intellectual property, intellectuals is something which floats all over. It's a global thing. So unless we get a similar or same kind of protection everywhere, it's very difficult to control intellectual property or to give a protection to intellectual property. And that's the reason, again, I reiterate that that's why we are here for the regional connectivity. So IPR is a different law. So far, people used to think, that IP is MNC, multinationals companies issue, but actually it is not. If you really look into it, it's a developing country who needs a strong intellectual property ecosystem. Why so? Because developing countries have the real innovation and they are into startups and all those things. So how do you protect a startup? The startup is not going to go just become a big company in a short while. So for every small thinking process that they do out of their intellectual, they need some kind of protection to make them go forward. I'll just quote a very small example. I have a son who is 11 years old, and once he wrote a slogan on pollution. So he just copied it from Google. So I told him, being an IP lawyer, I have been practicing IP for last 17 years, so it is in my blood almost. So I told him, don't do like this because this is not your thought process. Think something out of box. So he came and he wrote, pollution, every pollution has a solution. So I told him that's a very good thought process, and that's your original thinking. And with that, I wrote C under his slogan, which says copyright, protection of copyright. So he was so excited and thrilled, that for last 2 years, I have seen a sea change in his thought process. The creativity that he puts in his writing is mind-blowing. So every time he comes out, he asks me, Mama, can you write me C? Can you give me IP protection? And copyright is, it's a per se protection. So why I'm quoting this example is that he's a startup. Tomorrow he is going to become another startup company. So unless we start protecting people at the right level, things will not go. And developing country right now, they really need IP protection. So this session is more focused on technology transfer, but I think looking at the crowd and looking at the people we are sitting here, it's more important for us to understand that why we talk IPR when we talk about technology transfer. So who is transferring technology to whom? It's generally, things are coming from developed country to developing country, or things are going from developing country to developed country. So how we are going, who is going to protect those things? So IP is important again. So that is something about IP. And then, having why it is important that for regional connectivity, talk about regional connectivity for IPR is that, if you take an example of Bangladesh, since I handle all SAARC nation, I know how things are happening here. Bangladesh doesn't have a good IP law so far. So what is happening is that all, generic companies, they are not able to protect their IP law there. MNCs are not able to protect their IPs there. So what is happening is this cross-border things are happening. People are sending counterfeited from all over the world is coming. Somebody is blaming Bangladesh, somebody is blaming India, but nobody actually know where it's coming from. So if there is a regional connectivity on laws, enforcement, and the regulatory measures, like small example, like if custom officials of all these neighboring countries can come together and understand what is the enforcement mechanism and how can they well enforce their IPR law. So things will be more positive. Industry will like to invest in such country or in such region where there is a good connectivity. Because if suppose I am a big company and I am established myself in India, I'll definitely like to go to the neighboring countries because there is a porous border. And to add to that, developing countries have everything that you can think about. It has the real labor force, it has the intellectual, it has a good, young candidates who can be looking for a future. So here it is where the future is. So having a good connectivity on a law like IPR, which leads to the other platform, would be a great idea, and we'll see how we discuss further. And I'll be happy to take any questions you have, even if it's not related to this particular topic, provided we have time. Thank you.
Thanks, Shilpi. We'll now move on to, so we heard a lawyer, we've got somebody who works with the US government, and we've heard that perspective. Now we go into an industry perspective, and we have Parag from Qualcomm, who would perhaps introduce a bit of what he does in this with the company, and then how do they interface with the space we are talking about. Parag.
Thank you. So basically, I would like to basically kind of focus the discussion as to what is the purpose of any law or any regulation. Let's understand that particular piece, and then all the pieces will kind of solidify, and the picture will become very clear. So what we are trying to achieve is that we are trying to get the benefit of innovation, right, to the masses. That is the key, and trigger the economic activity. That is the whole purpose of this discussion, right? So if you look at this whole objective of getting the benefit to be realized to the masses, right? When the technology gets developed, the consumers get benefited out of the whole process, the jobs get created, the economic activity is spurred, the foreign exchange are saved, manufacturing happens. So there are various pieces. And in the process, what happens, innovation also takes place. The purpose of innovation is to create competitiveness, right? So if you are creating an environment where investments are easy to make, and the investments get the return, right, then only big players will come and do innovation. Otherwise, there is no purpose of doing any innovation. What we are going to get out of this, the whole process of innovation? And that is where the things are very, very, you can say that, it's kind of falls apart. And I'll give you an example. Look at the situation in India. I do not think that the laws in India are not properly written. They are all properly written. Maybe implementation is an issue. But still, we haven't seen huge amount of investments, right? Why we haven't seen investment? That is a question that you have to ask. Because since the investments have not happened, that's why there hasn't been huge amount of innovation, right, which the companies have generated here in India. And the main reason is that if you look at the overall structure, right, for the environment of cost of putting plants, let's say manufacturing plants in India, you'll find that there is always a slight kind of cost difference, right, compared to other markets. So India may be a little bit more costly. In order to prevent, right, and make the companies motivated to invest in India, the duties of components were raised, right? And that was one of the main driver of the government to make innovation, to kind of drive companies to put investments in India. And in the process, what they do is that they thought that the whole innovation cycle is going to get triggered, but it hasn't really helped. Why it hasn't helped? Because the duties were raised in the finished component, and the mobile. If you look at the mobile, I'll give you an example of mobile because we actually contribute in mobile. The handsets actually had higher duties, but components were being brought at zero duties. So when the components got bought in zero duties, there was no motivation to manufacture components. So it was basically a glorified trading. What's happening in India? Because it is glorified trading and there hasn't been any hardcore engineering work happening in India, right? And other markets are also similar, because I'm giving an example in India because it is almost similar in the Asian markets, right? Most of the Asian markets. That is why there hasn't been innovation. There is no design, because there is no need to design. Why would you design? The design is happening in some other markets. You're just bringing the products here and then selling those products in the market, right? And doing trading. And that is where the main, work needs to happen to kind of create an environment where cost-effective manufacturing can take place. The other problem that we have seen in here is that if you have seen earlier, before the UPA government, the NDA government came into power, there was a big plant in Chennai, Nokia plant. And that plant used to manufacture, handset not only for India, but used to also export. And the plant fizzled out, right, because of regulatory issues. But later, when the India government came, they basically brought in many manufacturers, so-called manufacturers in India. Now, let me ask you, what should be the metric for measuring progress of manufacturing in India? Should it be number of companies? Should it be the number of handsets being, manufactured in India, right? That is what the metric being used, right? And that's why you are basically getting a feel that, everything is very good, because you have got 150 companies, setting up plants. We have got 95% of the mobile phone being manufactured in India. But if you really see, the metric is how much foreign exchange has been saved, right? Because that is the real metric of value add, right? There are hardly any foreign exchange. What is the net revenue, right? What is the investment? The investment is hardly $500 million, right? That is where the problem is. The rest of the regulations, intellectual right, property right, protection, etc., will only come into place if this particular issue is taken care of. So what we need big players to come and manufacture in India, not all these small players, roaming around here and there, and they are just doing trading, right? If they really want to do, I'm not basically against small and big. I am basically trying to say that add value, create something which is unique, and use that to elevate your profile against big competitors so that you can compete in the marketplace, and in the process create a differentiation between your product and other product, which is not happening in the market because of the cost differential, because the market is just restricted to India. It is not getting expanded to other markets because the volumes of international volumes are huge, and we are creating an artificial barrier and just to basically take care of the local market. I will just stop here.
Thanks, Parag. A lot of very interesting insights, because I think from what Parag said, we've never thought of manufacturing in that way to say that, what is the end game on this? So there's very interesting stuff coming. So we've got quite a few questions coming up on Slido, and the first we have is for Shantanu. It says that how can developing countries such as Nepal, Bhutan, etc., compete with India's IPR regime? Take a dab at that.
First of all, why would Nepal, Bhutan, and all the other countries that were named, most of them LDCs, why would they have to compete with India's IPR regime? That's the first question. If you see global regulation under the WTO, where the TRIPS agreement governs the laws which goes in with intellectual property rights, you will see there are certain exemptions which are given to least developed countries as a transition to higher capacity. So you don't need to compete with any regime, number one. So you can very well carry on being competitive if you can without a very stiff IPR regime. But now your question, whatever question you had, put it in perspective of where I left when I started and what exactly Parag mentioned. I don't know whether the person is in the room. The answer would be more appropriate in that manner. If you, in any case, do not have the capacity to manufacture, whether you have a very good regime, IPR regime, or whether you don't, will not factor. These, for example, let me put it in perspective. India is one of the leading countries manufacturing generic pharmaceutical products. And I'm talking about legal generic pharmaceutical products. After the TRIPS transition period for India crossed over, they had to bring in certain strict IPR regime. Many of those companies were not able to carry on with the generic production. They had to change over. Why these companies did not go to Nepal, did not go to Bangladesh? I mean, later on few went, but the point is, why don't you see that the entire generic production moving to these least developed countries because they still had the ability to use as a sort of more lenient IPR protection regime. This is because IPR is only one part of it. IPR protection, going back to what Parag said, you need to have the capacity to innovate. Now, if you cannot innovate and you need to take help from outside, then it's all a give and take. Why will I come and help you if you don't protect my technology? That is where technology protection is required. But the generics would have been happy. So there is no need to have a sort of compete with any other IPR regime, including India.
Okay. Thank you, Shantanu. The next one is for Shilpi that says that what are the cross-country learnings for US and India in developing pro-innovation IPR regimes?
So, on cross-country learning, that if you say, there's something like giving the protection at the right level, like small example, like having a good type of protection like trade secret, or having a very strong law on contract law, which is the laws for innovators or for the startups to protect them right from the beginning of their thought process. As I said, the startup need a small level of protection. Not everybody or every startup can go for a patent protection right away. Even the thought process to come to a patent finally takes a lot of time. And every step has some kind of innovation or intellectual thing which is involved with it. So that's a kind of learning which is not only between cross-border India and US, it is learning for all over. Like the question that was put forth to Shantanu, as Shantanu rightly mentioned, that it is not about competing on the IPR front, but because IPR is something, as I said, it's a global law. So learning from each other that how a country like US, EU, Japan, how they have come to a level where they are today. Because they have really worked on the innovation parameters. And what are the innovation parameters? There are multiple things that need to work, like regulatory thing, then protection thing. But when it comes to IPR, small thing like having a good protection law in the form of trade secret or contract, or even small IPR laws like trademark and copyright, which is like basic right, which is easy to get, which is not like complicated as patent for which you really need to wait to develop your product. Suppose I'm doing some kind of patent manufacturing. In between, I plan that let's do naming of this product. And in between, I realize that, I'm not in a position where I can buy my stuff, sell my stuff, or get the stuff in the market. So what, as an innovator, I can do? I can get a protection to my trademark. And at the same time, I can use my intellectual capacity or the technology, product, or process, whatever I have brought in the market, to sell it or to license it to some of the big companies. So that is all possible only if we really do have laws which can be protecting innovators and startups. And not to miss that not only giving law for protection is important, but unless enforcement of things happen, things will not happen. So that's something we learned from US side again, that as Parag rightly said that IP law of India or any other law is quite up to date in India. The only major missing thing is enforcement and the parameters to judge as in where we are lacking behind. That is something really lacking, and it's not lacking. There's a very huge gap between laws and enforcement of the law. So that's the learning thing, that how to enforce law. Because when it comes to IP, it's just not about protecting it. It's like, first comes creation, then comes protection, then comes commercialization, and then when comes commercialization, then comes the enforcement part. So even if I am in the market with my intellectual capacity, who is protecting me? So for that, a country needs to have a good enforcement mechanism in place.
No, thanks, Shilpi. I think that answers the question quite a bit. And there's one more for Parag here that says that what are some of the anti-innovation IPR practices prevalent in countries such as Nepal and Bangladesh? How can they be fixed? Are you aware of something like that, or that's something you can, yeah.
So as I mentioned in my...
Anonymous people,
Yes.
That.
So in our capacity, we work quite a lot with the region, and recently, we have been helping government of Pakistan, Nepal, Bangladesh, and Sri Lanka to work on amending their IPR law. So that's why I thought it will be good for me to take up this idea. So like in Bangladesh, Bangladesh is still under LDC and it will be under LDC till 2024. So what is the issue is that they don't even have a proper intellectual property law and they have no law on pharmaceutical, like there is no patent law. As well as there is no data protection or some kind of security for data in the law. So that's something which is missing in Bangladesh. But government is working on that. In fact, we are collaborated with government to see that their IPR law is being upgraded as per the international standard and with whatever exemptions they have as per TRIPS guidelines. And there was a question for Nepal also.
Yeah, so basically, what are some anti-innovation IPR practices prevalent in countries such as Nepal and Bangladesh, and how can they be fixed?
Okay, so Bangladesh is something that is, in Nepal, Nepal has an intellectual property right, but small laws like trademark law, the kind of protection or the kind of section, the way it is being worded is totally anti-innovation because it says, whoever comes first, they'll be protected. Suppose if I have a trademark called Bisleri and I'm in Nepal, I can file it. And if I'm the first one to file it, it will be their right. It will be my right. So Bisleri, even if it comes later on, they'll not be protected as per the present law. But again, they are working on the intellectual property law and the present government is really wanting to change it thoroughly and they want to make IPR as one of the, attraction for investors to come in the country.
Thanks, Shilpi. I think there was a question for me also on Nepal about the same thing, and just want to add what Shilpi said. In Nepal, that's been a challenge. It's a big challenge when we work with our clients also. So it's a classic case we take is an Indian product called Ashirvad, which is from ITC stable, and all Ashirvad is found in Nepal in the same logo, in the same form, the same products. And the most interesting thing is that a good part of Nepal watches Indian television channels. So you don't have to really spend money on any of the advertising because everybody is watching Indian television channels, and so that's a major violation, and that's not something. So there was a question for me on that, and I said Nepal is trying to work on some of the long-term stuff. So before we open up, I think there was just since this is a question for deliberation, that is.
I'd just like to add a couple of things because I think the mix we have the audience is mixed. What's wrong in having Ashirvad and a Nepalese version of Ashirvad and getting registered? Now the point is, when we think of a product and we identify a name with the product, so for example, this Bisleri, we are considering that if I pay certain amount of money and I get this water, I'm 100% sure that if I drink this water, I'll not fall sick. The quality of the product is attached to the name. Now, if I go home and in a really rickety condition, not hygienic, absolutely unhygienic condition, if I pack the wheat flour in the Ashirvad, exactly the same logo, same get-up, and I sell it, people who are buying, looking at the advertisement, they will think that they are buying something which is of a higher quality. So you are actually, what is happening for the company, someone else is passing off their product as if it is of a better quality. And this is absolutely unfair in trade. Apart from the consumer who is buying is lost as to what the person is going to take. This is only an edible matter. The law actually restricts anything which is phonetically similar, apparently similar. So when I started practicing law, one of the first case was Reynolds. It's writing equipment pen. So believe me, I never in my life knew so many spellings of Reynolds. I mean, Reynolds and all sorts of spelling. All of them, if you look at, Reynolds, apparently you're not spelling the particular word to understand whether it is a fake or not. So apparently similar, the casing of the thing, this is similar, or the blatant copy. All are restricted, whether it is in India or Nepal or Bangladesh, but rampantly it is happening. In India, they have controlled quite a bit, but still it is happening. And in all our neighboring countries, the control is not as strict as required.
Okay, I think before we take questions, I just want to sort of move the discussions a bit around, sort of contextualizing what's happening now, and to say that if you're looking at is there a possible, or if there's a framework, what could be the framework? This has been a question that we look at as a digital single South Asian market. Now, is that too early to think about, or is it that each country is having its own issues, so you take a more of a South Asian perspective, or you sort of maybe I would say maybe look at BBIN. Joyita is here; she'll be very happy about that. So is there a perspective we can look at in terms of a digital single South Asian market? So maybe a few minutes, your own responses. Parag, you want to start off?
See, as far as the digital, integrating the digital market, South Asian region into a single market, there are various dimensions. So one is basically on the trade dimension, right? You need to have a free trade agreement with the nation, so there are no barriers, right? And maybe the government already has initiated, and there are a lot of free trade agreement with the government has signed, right, with the Asian countries. But going forward, I personally believe that the market forces basically play an important role. For example, if the operators, right, can collaborate for single procurement, let's say if they're procuring devices, and if they kind of collaborate with the other big operators, right, to kind of come out with a collaborating forum where they can procure devices, right, in large scale, or maybe standardization of those devices in large scale, then what happens is volumes increases, and the volume increases, the cost of the devices goes down. So, because one single market may not be able to deliver so much amount of volume, because ultimately it's a game of cost and volume, right? So therefore, I believe that synergy can exist if we standardize, make the products uniform across the various countries, because these countries have similar requirements and expectation, and the environment is also similar. And we actually basically come out, let the market forces collaborate without any restriction. That's what I would basically.
Shilpi, you want to add something to that?
So since I'm not from the ICT background, but what I perceive from the existing law within the country, I feel that unless all the countries have a minimum standard of law in place, digital connectivity would be little, hindrance sometimes, because, India may be on a stronger position than Nepal or Bhutan. So unless everything is, I would not say standardized, but at least to the level where it's, international norms have been connected. So right now, if you really ask me what is the first thing on IPR that government of all these SAARC nations should do, is that they should have a good law on enforcement mechanism, which should be common for all of them. So that's
I try, and I will be more optimistic. Coming from India, a few years back, there was the NDA government, which is even now we have an NDA government. There was another NDA government, and the government was the largest coalition government in India that we have seen. Many of the parties which joined the government were absolutely at loggerheads before they joined the government. And they all managed to complete their tenure. This is one example. I will go why I'm saying that. If you pick up Germany, so one developing country, if you pick up Germany, I could never believe that the political parties with an absolutely different ideology, with FDP as well as Green Party coming together and forming a coalition. Now, why am I saying this? The developing countries in the SAARC region, they have their own focus. They have their own requirements. Some may be a little lenient on some laws, some may be very strict on some laws, whatever. But there can be a common minimum program on the basis of which there can be a guiding principle of digital policy, guiding principle of IPR policy. When I say digital policy, what is required? Bhutan government has already declared on the internet the speeding up of broadband. Similar, I think the deadlines I cannot remember. Similar, the Sri Lankans have. Similar, the Bangladeshis have. Bangladesh is 2021 or something like that. every country in SAARC, they are looking at some of the common areas, that is high-speed internet. So look at what is common in all of them. I cannot say that India would say no. I cannot say Pakistan would say no. So areas where you need a common policy which is possible to effectively enforce, go into that. Now coming into why, if the TRIPS allows me to have some exemptions, why should I protect? You have a common IPR guideline policy where who is stopping you from utilizing the patent data which is there, the test data which is there, all these data, index them, collate them, use them for technology transfer. That's on one side, on the non-market mediated. On the market side, make sure that blatant copies are not happening. Make sure if I come in and I want to bring in a new technology, an advanced technology, tomorrow someone would not come and blatantly copy. Then I will never come. So you can have a balance of both, a market mediated and a non-market mediated in a policy, but we need to have the will to have such a policy. If the will is there, the government will run for the tenure that they are elected for. That is my approach.
So I think I'm very tempted to ask another question before I go to the floor. And I think, when we were, from yesterday, we were having this connectivity discourse. And one of the things when we talk about connectivity is that we are only looking at South Asia, and, we are not talking about the big elephant in the room, which is China. And China and IPR is a big, big issue. I mean, so if you look at even now as Diwali is approaching, all our gods are coming from there, So if you think from that perspective, and so that's a big thing that you see, and there is also, if you look at in the discourses around in Nepal, also to say that here is a China model of things. If you look at how things move on the internet, or how sort of copying happens, or how inspirations happen, or how sort of products are. So then you are also competing with that sort of world, So any perspective on how does that have an impact as we go on? Because of course China, we hear they are tightening on some of the fronts, but then that is a huge thing, because you are always going in there and you're flouting your whatever your laws in your own country, getting the products as Chinese products. So a lot of these things are happening, and also in the digital space we see a lot of that stuff happening. Anything you can buy on, like if you're sitting in Bangladesh, you can buy on Alibaba, get your stuff out, So any thoughts on that as to how does this dovetail into this discourse as we talk about an integrated market, or is that possibility, or in the next 5-10 years? Parag, I think you are very tempted, I know.
See, I am not an expert, right? But though I would like to make an attempt. See, look at China. China actually has a different kind of framework altogether. First is the big population. It's a big country, right? And therefore, if you look at China has been able to drive a model like that because of the domestic volumes have been able to deliver businesses what they require, right? Because that is where you can't really expect Bangladesh or Nepal drive a similar kind of model, right? So it's very clear that they actually have an advantage, which is population. There is a demand, right? And the populations are ability to pay because the markets actually have grown up and their disposable income has increased. And that is where they are taking advantage of, and therefore the Chinese companies who are pushing a model like this is able to get away, right? Because of this reason. Now, how long it will continue, I really don't know. I really have no idea as to what kind of problems which may come later. But every geography is different, right? What model China has followed, India may not be able to follow the model. The reason is that what India needs is to trigger innovation, right? There isn't a domestic player, Indianized domestic player, who actually is innovating in real sense, right? So in order for that player, right, to come up, right, and start competing with the global players, you have to synergize and collaborate with the global. You have to be part of that global framework. You cannot basically say that I'm going to create my own framework and start working on that. So you have to be part of the framework, which means that you have to respect IPR policy. You cannot say that I'm not going to respect IPR policy, because then you become an island and you'll never be able to grow. You will be stifled. So I think, look at the model which has been practiced in China, what model we can practice because of the democracy that we have, because of the different kind of views that we have to respect, right? We cannot just bulldoze our way through, right? Just like what happened in China. But a democratic model definitely is much more resilient from a long-term point of view. Everybody knows that, right? And because the risks are mitigated. So I believe that we have a good future as far as India is concerned.
Thanks, Parag. You want to add anything, Shantanu or Shilpi, on this?
So at the end of the day, what is important to understand is, what are we protecting? If you pick up Chinese model, around 12 years back, I was doing some research. I was in Geneva that time. We were trying to see how traditional knowledge can be protected under the WIPO convention. And we thought that, okay, China protects, let us see. We could not find anything. And then we realized, talking to Chinese experts, we realized the traditional medicine of China was protected under the cultural laws, not intellectual property rights. So, and the punishment was extremely stiff, even imprisonment and stuff like that. Whereas at the same time, there was a parallel on intellectual property. The law was different, and there were rampant violations at that time. By the way, now the Chinese IPR protection is pretty good, very good, no doubt about it. And even on the competing side, I am saying that. But at that time, if you saw, when it was their interest, their property, they were protecting. And whatever they were getting from outside, they were not protecting. So now, when the Chinese, exactly what he said, when the Chinese innovation starts growing, and the intellectual property is being created locally, the protection level also goes up. Same had happened with US, same had happened with Switzerland. It is a matter of time whether you can graduate to that level. So everything is dynamic. With the move, whether the region, whether Nepal, Bhutan, or the other countries, and India, we need to move. If we are static, then it is the end.
Great. Shilpi?
I'll just share a small example. Every time when we meet all government officials in all the SAARC nation, most of the government who are trying to amend their IPR law, they talk about utility model patent, which is a patent protection for small innovation. So, there people are trying to ape Japan or China, which is again, as Shantanu said, it's not the thing that you should try and copy others' law, but you should see your common and your environment that you have in your country. Suppose tomorrow Nepal comes out with a utility model patent, which is a patent granted to a small innovation, enhanced innovation for a limited number of years. So who is going to benefit from that IP protection? I'm sure the country per se, since they don't have that innovation culture right now, I'm just taking example of Bhutan, Nepal, whoever it is. So because IP is a protection which you just cannot afford only to your people, but also people coming from, innovators coming from different countries. So countries like US, China, Japan, they have a big innovator hub. So they'll be the one who will be getting more protection under utility model patent. So this is what I'm saying, is that just copying others' law as in how they have come to a level would be a dead end for the other countries who are still in a developing age, because other countries have already reached a level where they can use other system. So the only way to work it is that have a international standard of IP law with whatever exceptions you think your country is specific, and then work really good on the enforcement aspect. I really emphasize on this point that even if you don't have a good law, but if you have a good enforcement practice and mechanism in place, things works out very well. So I think that's
Thanks, Shilpi. Okay, so we've got another question coming on Slido. It's for Parag. So countries such as Taiwan and Korea have moved up the semiconductor global value chain over the years. Why do you think India is lagging? It's a specific question.
See, I believe that India basically need a local player, an interested local player who can actually invest and start innovating to a level which Korea and Taiwan local players have done. If you look at Korea and Taiwan, it is not just about the GDP alone, right? It is not about the upliftment of their population. It is about local interest. And the players who actually are innovating or manufacturing, they are innovating too, right? And here the model that we had in India is that there have been huge amount of phones which are so-called manufactured in India, which is not manufactured, which is assembled in India. And though we basically brag of volumes, 95% of them, but there hasn't been any innovation, right, in real sense. There have been innovation from the point of view of marketing, etc. Those are also important in business, but technology innovation is lacking. And if technology innovation lacks, but then what happens is that the synergy of the market between the business actually kind of falls apart. Because every market is different. Korea market is different. China market is different. Taiwan is different. So if you start importing products which are from Korean market, which actually works in the Korean market, it may not be possible for those products to work in India. Because India, the population structure is different, the ability to pay those products. So you are importing something which has been developed in US, so it is being imposed upon us. Most of the time it is like that, it is being imposed. And that is where the problem is. And that is where the things really do not synergize well and the market does not work well. So we need a domestic interest. And that's why the government needs to facilitate and trigger real hardcore innovation, design, and others. And today, all the policies, unfortunately, I have been very vocal about this. PMA actually hasn't really worked that well because it has only focused on raising duties, right? Custom duties. And the custom duties actually creates contradiction because there are nations which are on FTA, right? Those becomes a path of leakages, right? Which happens. And you are not able to take care of the global market at all because you are not focused on reducing the cost of manufacturing because you are uncompetitive, and once you are uncompetitive, nobody manufactures. That's the problem.
Thank you. So maybe we open up the floor for questions. So whoever would like to ask questions, please raise your hand. And please be brief, okay? And please introduce yourself and let us know who is the person you would like to ask the question. The lady at the back.
Thank you very much. I'm basically completely novice in the field of IPR, and probably this is the first time I'm listening.
Can you introduce yourself, please?
Yeah, sure. I'm Joyita Bhattacharjee from Observer Research Foundation. I'm basically a scholar on South Asian relations, India's neighborhood policy. So it's very fascinating to hear about the present discussion on IPR. But here the focus is South Asia. And South Asia, when it comes to, we have deep cultural relations, and we share traditions, and also handicrafts. So when it comes to handicrafts, how really, because now we are seeing that like some countries are trying to get patent on handicrafts. Recently, Bangladesh had patented Jamdani. But the similar kind of handicrafts exist across the border. So whether this kind of patenting system is going to create tensions, or this can really lead to, basically how we deal with this kind of things and how we can deal with these issues. Thank you.
So maybe we'll take a few questions and come. So this is on patenting on handicrafts, question number 1. So.
Good afternoon. I am Siddharth Narayan from Cuts International. My question is for Shilpi. This is with respect to the startup hub Nexus that US Embassy has started. So congratulations for that initiative. We were talking about how startups need to be protected and how they need to be incentivized for innovating, etc. So I just want to know that through your startup hub, in case there are any insights that you can share with us with regard to the perception of startups towards IPRs, in particular the level of awareness or maybe capacity and the level of importance that they give to innovations and to respecting IPRs, etc. And are there any similar initiatives which you're running in the region, maybe in BBIN or in South Asia, etc.? And has there been any effort for facilitating cross-learning or maybe sharing best practices among startups or bringing them on a common platform? So that will be my question to you. Thank you.
Okay, one more. We had a hand at the back.
Thank you. Am I audible? Thank you. Uday Mehta from Cuts International. Specific question for all the 3 speakers. To begin with Parag. There's this whole movement of skills development in India, Parag, and I'm sure the ministry is also pushing a lot of pressure on creating skills. But my question is whether the target for skilling in India, is it more towards creating more of software development, or is it more towards hardware manufacturing? And what is it that what should be prioritized? My second question is to Shantanu. The elephant in the room in various conferences which one goes to on reforms is you always get stuck with this term called political will. If there's a will, then things will happen, right? How do you define the political will, and where does one go to find this political will? That's my question to Shantanu. And my last question to Shilpi is this big movement and campaign on Make in India. I'm sure, to be very frank and open, that while Make in India is good, but it's not really translating in the kind of jobs which we need to be created in India, right? So that means we need to move from Make in India to designing in India. What is it that we can do to achieve that movement? So thank you.
Okay, so we'll take, okay, one more then.
Hi, this is Akriti, and I'm from CIRC, that is Kurtz Institute for Regulation and Competition. So my question is basically to Ms. Shilpi Jha. I have two questions. One, actually I was reading an article yesterday that was on patenting in India only. So it was written there that in India, patenting is very less as compared to China and US, obviously. And one of the main reason is ignorance, lack of awareness among people. And it was also written over there that in US it is very easy to get patent. So if you have an idea, then the first thing that you think of that idea is just to go and get a patent on that. And in India also we do not have a regime where software patenting is allowed or plant variety patenting is allowed. So I just wanted to have your thought on that. That do you think that there is a kind of any modifications or any kind of changes are needed in Indian IPR regime first? Second question is related to the patenting by universities basically. So in US we had Bayh-Dole Act in 1980. And after that, many developing and developed countries also followed that Bayh-Dole Act. In India also, we tried to pass one act in 2008, but it was not passed, unfortunately. So do you think, because here we are talking about Startup India, Skilling India, and universities and IITs are also one of the main source of innovation and new technologies that are coming out in India. Many spin-offs are also coming out of IIT. So do you think that in India, many central and state universities should also think of creating such kind of technology transfer offices or not? So any other changes in the IPR regime in India is required or not?
Okay, so I'm also looking at the clock, so maybe around, yeah, you got, okay. We take, so this is the last one we take, and then we just have 3 minutes. Yeah.
So yeah. So I'd like to ask.
Please introduce yourself.
I'm Prasenjit Lahiri, representing Social Friendly. So we are a digital consulting firm working out of Southeast Asia. So now we work with a lot of freelancers who are designers, and many of them are in Bangladesh. So they ask us, this is a conversation we also were having before, that as freelancers who are not registered businesses, what tools they have to protect their designs. They're not painters or artists per se, but because they sell their work, but do they also have to sign off all rights to it, or do they? What are the rules in place to that? So if you can just shed some light.
So this is very interesting. A bunch of questions. Hopefully, panelists. I'll just prompt if you guys have missed out anything. So we'll start from here. Shilpi, come on.
So I think.
So you have the startup hub question.
Okay.
And then you have the patent question on US.
Okay.
Why is it easy in US, and about universities. Those are the three things. And then you had Uday asking about Make in India.
So on startup, first of all, thank you that you appreciate that initiative, and in fact, we are very proud at US Embassy about that initiative. In fact, that initiative has not been even 1 year. It's just been 1 year since started, and we have seen a sea change in the way startup or innovators have coming and started connecting with us. So the first question that you had, I think, was about the level of awareness and what you think about the startup, those who come to the startup hub. So frankly, out of the 100% people, those who come there, 80 are not aware about intellectual property. So what we do in that startup program is that we always have one IPR session to let them know that IPR is not about patent only, but there are many other aspects of it or categories of it like copyright, trademark, design, which any startup would have, even if he has just started his idea from a scratch. So that's something is there. And second question, have I answered your first question? Yeah, that's okay. So second, your question was that whether there is such kind of organization existing in other countries also?
Just one more thing that, I mean, it's not just about awareness, but also about the level of respect that they give to IPRs. I mean, have you come across cases where you've seen that, okay, IPRs are being violated as well? Or it's also about that, do they recognize the importance of IPRs, do they strive to get an IPR? Maybe the low level of awareness has already
Right.
answered
So
that
that
question
80% of
partially.
non-awareness category, somehow because of the lack of awareness, they have violated IPR also many a times because they don't really understand that importance that a distillery has a goodwill in the market. So for them, it's if they don't understand the IPR, what they do is that they use distillery for some other. I'm just giving an example,
Yeah, sure.
without realizing that they are infringing on somebody's IPR and I would not say disrespecting because they are not aware of it. So most of the time, that is what happens. So, but once they understand what is the importance of IPR, they do start respecting it. And in many of our cases, which whom we have trained, they have started applying for IPR protection. So that's very positive, and that's why I keep saying, in fact, Make in India will also have that aspect attached to it. So another question is that other countries, yes, most of the countries now, they have a startup hub. Like small country like Bhutan, you won't believe, they are already at a level where India is still trying to be, frankly.
Yeah, that's how the cross-learning question came.
Yes. So, I work with all these countries, and you won't believe Bhutan is just doing best amongst all these countries, including India. Why I say this is because even being such a small country where investment is not really happening, that countries only thrives on tourism and on energy sector. Even then, they think about having a strong IPR protection and how to enforce things. And they have all kind of startup companies coming and developing their law. And similarly with Bangladesh, we have startup center. And so all the countries have their startups. The question is at what level they are right now. So countries like Pakistan, Bhutan, they have come to some level, and Sri Lanka, of course. But country like Bangladesh, Nepal, we also work with Afghanistan. So their things are still, lying low. And but as a government will is talked about, so there is a government will. The government has started realizing that IPR is a key to attracting investment, and that's an easy take for any company to come in. So that's happening. And third question was on connectivity. So I don't know how government is working on that, but US government is really working on connecting these startups. So every quarterly we have this startup meets. In fact, it's going on while I'm here. It's happening at the center. So what we do is that we have picked up some of the key leaders in these startup hubs, and we meet every quarter to understand where things are, and we do get case studies to talk amongst each other, that what is the issue happening in Bangladesh and how a product in Bangladesh can go to Sri Lanka and all those things. So that's we doing.
So are you also just?
So I think let's not make it a distinction.
Okay.
She has to answer two more questions. So okay, we can have some discussions over tea. So yeah.
So I believe your first question was why granting a patent is easy in US, right?
Yeah.
So that's because US is a developed country. You have to understand IP was talked, as you say, Bayh-Dole Act is in 1986. So you can think that concept of having a technology transfer issue existed since 1986, which is still not happening in a country like India. So that is there. And in US, for every patent examination, there is a subject expert. Examiners are technical engineers. They are not lawyers. There are many lawyers also, but that's the major qualification, that if he is examining a biotechnology application, he needs to have a biotechnology background. So that expertise is there, which helps the examiner to examine the patent application easily. At the same time, the infrastructure is really good. There's a timeline that everybody follows, which was lacking in a country like India, and of course it's lacking in the other countries. But Indian government has recently made a lot of changes. A lot of examiners have been, taken on board, and now things have improved over the last 6-7 months.
Okay, so maybe we'll move on to Parag to
You had
answer the
another question, but we can
I have.
take it
We'll
later.
come back.
I have.
Or we can take it
Yeah.
later.
Yeah.
Yeah.
Yeah. So on skill development. in
Yeah,
India,
so it's very
there's-
interesting and very important question. See, so what is the framework under which the software skills develop, right? So let's understand that. See, if you look at the Indian software development history, you will find that India actually has been supporting software development, and there are big companies which came up, and in the process generated an environment where skill automatically developed in India, because there are big companies who have been doing this work for decades, right? And therefore we have in slowly able to develop software skills, and software skills, the tools are very easily available, right? You don't really have to run for these tools, because these SDKs, kits are all being promoted and being available, and you can learn these skills very easily. Whereas in the hardware skill development, it is a little bit difficult. You can't really learn hardware designing in colleges, right? And even if you have hardware designing in colleges, that will be very, very archaic, and those technologies have quickly changed, and you have moved forward. Or unless the education institute has got a tie-up with the corporate, right? And that is very, very critical. So if you look at in India, the problem is that there are companies like Qualcomm. We are there. We have been there in this market for such a long period of time. Almost like 15 years we have been there. And we have a huge development center here, right? And we are trying to incorporate skills of designing. But the problem is that because there are no ancillary setups which are kind of being leveraging this capability that we are here, we have been able to kind of provide in India, this thing is not picking up. So it is not just about the technology player presence in the market, because it is very important that the key technology players like Qualcomm, Intel, and others should be there in the market. They should have the development centers. India should facilitate these players to play in this market in order for the skills to get developed. It can't be through just training, right, in colleges. But somebody should be there to leverage them, right, and generate products and large-scale products, right. So that's how it should be. It will happen. Thank you.
Thanks. Okay, Shantanu, I think there are 3 questions for you. One is on the handicraft question that was there. Right. There's a political will question, and maybe you want to also answer the designer question.
Yeah, and to add, I slightly differ with Shilpi on the issue of why in US they get very quickly the patents, whereas not in India. I agree with Shilpi on most of things what she said, that the capacity of the Indian, even in India, in Indian Patent Office, there are experts very focused on the innovations on which they are patenting, they are examining, sorry. But the numbers are so small that, I mean, it's like the judges and the number of cases. I'm giving this example so that you understand, immediately you understand. So each examiner examining a case is huge number of cases, I mean, patent applications. So on the capacity side, it takes more time. The second, on the system as such, the patent, grant of patent system in US is more, okay, check and grant. If there is a problem, there would be a litigation, it will be settled in litigation, and most of the litigation would be settled rather than litigated till the end. Our system is more like the European system. The examination is very, very stiff examination, which takes more time. So both the systems work, and both the systems have been working in different countries. So there is 2 different ways of looking at it. In US, the patent right is constitutional. I'm not going into the details. You are with Kurtz and the Competition Institute. You do your own research on that. So so I wanted to make this point very clear. Now going into Ms. Bhattacharya. Yes, I got your point. So it is not a case of patents. It's a case of geographical indication. So if you have since you come from the area where you know about Tangail sari or even the Kanchipuram and all those particular saris, they are coming from a particular area, geographical area, which is unique. So that gets a protection which we call geographical indication. Jamdani gets a protection in Bangladesh. Now, similarly in India, Jamdani in certain state, Jamdani is also popular. Now it is a disputed matter. If 2 states like Odisha and Bengal can dispute on Rasagolla, then you can definitely understand the two countries, Bangladesh and India, can dispute over Jamdani. But the protection is geographical indication. It's not patent. Patent is over a protection for inventions. I'm not going into the micro details. But this is the unique product from that unique place, geographical place. And that protection is there. Conflicts can happen anyway. Conflicts are to be settled. So that's your question. And
there's a designing thing and then the political will.
Yeah.
And the small designers in Bangladesh and others, how can they protect their work they're doing?
Exactly. So the point is, the protection is not only for big companies like Qualcomm, or even the Chinese companies, but also for the small designers. So the protection is there. So the point is, the protection is not only for big companies like Qualcomm, or even the Chinese companies, but the protection is there for the small designers. So the point is, the protection is not only for big companies like Qualcomm, or anyone else. The design protection, well, I mean, my law firm's name is Lege Chambers. I've applied for a trademark, and the logo is already registered. I've not yet completed 2 years of the law firm. Similarly, I'm absolutely sole proprietor, independent, very, very micro boutique. So the point is, these designers, where they want to market, where they want to work, they can jolly well go there and take the protection, and it is not expensive. And number one. Number two, design protection. We call in India, we call it registered design protection. In America, in United States of America, they call it design patent. In different countries, different. So it is very much possible. The point is, this is not a forum where you solicit legal advice and I give you. So the point is, there are many who can go look into it. Now, coming into my dear friend Uday's question as to the big elephant and political will. Well, I think I would go more with your organization's research, rather than your view. The big elephant is not the political will, and this present government has shown it. The big elephant is Indian bureaucracy. The big elephant is Indian bureaucracy. Make in India, Prime Minister and all the cabinet is shouting from on the top of the voice. But Make in India, Prime Minister is not going to do the Make in India alone. The Indian bureaucracy, the defense sector, these are live examples which I am not speaking. Everyone knows about it. So the point is, it is the big elephant in the room is not political will. Even if you have political will, and there is political will, things will not move. When Parag was answering, he mentioned about PMA. Many of you would not understand PMA if you're not working on trade areas. Preferential market access. The previous government had a very, very protectionist way of bringing in PMA. And that was disputed, that was challenged by all countries who are trading with India, not just USA, all countries. They had to stop it. The point is that the issue will be solved when not just there is political will, but also the will to execute it for the entire executive and legislative.
Okay, I think we are coming to the close of, I'm just looking at the watch, and maybe we would end in a slightly positive note. And it's not that we have to be positive, but to see that, a quick round, about 30 seconds, to say that how hopeful are you that these changes are going to happen quickly in terms of, integration, in terms of, sort of the recognition of this issue of IPR, the awareness. How hopeful are you? So quick 30 seconds, everybody, and then we'll close.
I am a positivist and an optimist. And I see that it is already happening. We are sitting down here in a connectivity conference and discussing intellectual property rights, where I think most of you are not necessarily directly related to intellectual property rights. We are in some way. That shows that there is a will. Now, if we go back to our own constituencies and push it, there would be definitely a discussion. Even a photographer here, who is creating innovation here, so would be able to bring back some certain level of understanding. We have to go back. We have to raise this issue, and once the discussion goes up, spreads around, definitely governments will pick it up.
Thanks, Shantanu. Parag?
See, I can basically see the intent, right? It's all about intent. So I see that definitely the intent is there, but there have been a lot of, past legacy issues to manage, and therefore it is taking time, right? Otherwise, I believe that, from an intent point of view, the government is quite clear that unless you do that, we will continue to be left behind from the point of view of growth that we are looking at. Thank you.
I agree with both of my panelists. Scenario is very positive, whether it's India, Nepal, Bangladesh, Bhutan. And in fact, somebody yesterday mentioned that somebody said borders should not be barriers. I feel very soon borders would be a trade boosters for everybody. So things are really positive. And of course, we are sitting here, as Shantanu said, he has stolen my words. The very first line I said is that the very fact that we are having an IPR discussion in regional connectivity program, that talks quite a lot about it. So thank you for being here.
Thank you. I think it's a round of applause to our panelists, Shilpi, Parag, and Santanu. And I think just borrowing your words and sort of borrowing your thoughts, I think every conference that works around connectivity or works around business or trade, I think IPR should be a part of the discussion. And I hope, next time when we are having a discussion around this, it becomes a permanent future. Thank you very much once again for all the interaction and to the panelists, and I would hand it over to Bratinder.
Thank you very much, everyone, particularly the panelists. Thank you, Sujeev. Now, just before we conclude, we are pleased to present the Grow Tree certificates to our respected speakers. I request Sujeev to present it to the panelists. These certificates have been supplied to us by a non-profit organization who will plant trees in your name somewhere in East Sikkim. We have one in the name of Mr. Sujeev Shakya as well. I request my colleague Akshay, who has worked very hard in putting up the show, to hand it over to Santanu. Thank you very much, Akshay. Now, we have come to the end of this program. The refreshments, instead of at Rani Bagh lawn, we have arranged the refreshments at the Shah Jahan room, which is just down below one level. Please do join us for some tea, coffee, and refreshments. And we are coming back here at 3:30 for the next session. We hope to see you there too. Thank you very much. Thank you.